so that'd be great. Today is all about what happens next. So you filed for divorce, someone's filed a response, now you're waiting, right? You're wondering what happens now. What are we going to do? Somebody decides, right? They look at the petition, they look at the response, they make a decision. The earrings are hitting the AirPods, so we'll take those out. So
You sound great.
clicking. Oh, I do.
But I don't think that it has anything to do with the ear. I think that you're on your computer.
Got it. So today's about pre-hearing conferences. What we've done in the past is we've talked about how to find an attorney, how to know if an attorney is working well for you or if you should ditch your attorney. Number two, how it is that you can determine how much you should be spending on an attorney, how to do a very logical cost-benefit analysis to determine how much you should set aside to spend on your divorce, and all of your different options as far as using attorneys, using certified legal document preparers, or just representing yourself, or using an attorney in a limited scope fashion where maybe you don't use them for everything, but you are consulting with them. Today, and then we talked about evidence, how to determine what evidence you need, how to gather evidence, how to organize evidence, how it's admitted once you are in court. Today is basically about what we call here phase two. So we break a divorce into 3 phases. Phase one is the petition and the response and kind of that initial strategy, figuring out what's going to happen. Phase two is about gathering documents, doing these pre-hearing conferences, which are non-evidentiary hearings in front of the judge, or court-ordered alternative dispute resolutions and mediations and negotiations. That's phase two, and that's what we're really going to talk about today. After that, phase three is really when you're going to trial on some issues or all issues. If you know that you can't negotiate and settle your case, then you are looking at going to trial, and that's phase three, and we'll talk about that as well. So overall, what we're doing is an 11-part series on all things Divorce Arizona. And the first half of the series is on the procedures, how to get through the process procedurally from start to finish. And then the second half of the 11-part series is about the substantive law, what you need to know about the law concerning property division, custody, that sort of thing. So with that, we'll go ahead and get started. After that, petition's filed and the response is filed. If you don't agree on everything, then you'll go to some sort of pre-hearing conference. If you do agree on everything, what you'll do is you'll draft a consent decree and file that with the court after your 60-day waiting period, and you will be divorced. Or if one person doesn't respond, then you will file an application for default, and you will end up being divorced via default. But if one of those two things isn't true, then you'll move forward to this phase, pre-hearing conferences. And now a lot of people think, okay, if it's uncontested in the beginning, then we're settling it. And if we move forward to this phase two, then we're not settling it. And that's not what this means. Most cases settle at the end or sometime in phase two. So there are all these different names for these pre-hearing conferences, and it can be really confusing. So we're going to start defining them. Pre-hearing conferences are non-evidentiary hearings. That means you're not presenting evidence. You're not arguing your case. You're doing other things. You're figuring out if you need experts, court-appointed experts. You're figuring out if there's any issues that you agree on. So you're narrowing the scope of your litigation and kind of coming up with the procedural rules for how things are going to go down during your divorce or your custody action or your modification action. This is not limited to divorce. It's really any sort of family law case here in Arizona. And I'm in Maricopa County, so most of what we're talking about here is pretty specific to Maricopa County. Not that it's not relevant all over the state, but you may find that your county has different names for things. But we are talking about so many of them, I think we're probably going to cover whatever it is that you've got going on. So today we've got pre-hearing conferences. Coming up next in the remainder of the series, we're going to talk about divorce negotiations, trial preparation and presentation. That's kind of a big one. And then we'll get into the more substantive law, divorce law, custody law, child support, spousal maintenance, and property concerns. So One of the most common pre-hearing conferences is the Resolution Management Conference, or the RMC. That is typically, in most cases, what happens after a response is filed, and it doesn't happen necessarily quickly. Most of the time, the judges go ahead and set them preemptively without you doing anything. But if you find yourself stuck, you filed for divorce, your spouse has filed a response and it's just sitting, you may want to file what's called a motion to set a resolution management conference, because they're required, and that's what comes next. This is a half-an-hour hearing in front of your assigned judge. So you've been assigned a judge. This judge will hear your case unless you decide you want to change judges. And there is a mechanism for doing that, but we're not going to talk about that today unless there are specific questions on that. And a note on that before I go any further. So the way that these seminars are set up, there is a presentation of information, and then there is an open Q&A format. And people send in their questions, and we've got a bunch of them here, but you can send in your questions as well. Anything that you are wondering based on what I'm talking about here today, you can text that in, you can email that in, you can private message. Caitlin, right? Are you on?
Yeah, they can also text message. I've got the text open.
Okay.
Or they can private message me on
Great.
any of the things.
So feel free to send in your questions if I say anything that's confusing. So back to the RMC. Before you go to the RMC, the Resolution Management Conference, you're required to file a resolution management statement. The statement is straightforward what you want. This is my position because. You're not arguing, you're not offering supportive evidence. You are simply saying, here's what I want on this issue. And the way the Resolution Management Conference or statement is lined out is almost like an outline. Like on custody, I want being. On child support, I want being. On attorney's fees, here's what I want. And you need to complete your statements without argument and without emotion. That can be difficult, but that's what you're aiming for. Since this is your first time in front of the judge, you're going to want to make a good impression. So this is an example of an appropriate statement for a resolution management statement. Mother, like you're talking about yourself as you're filing this, mother should be awarded sole legal decision-making because father has been convicted of selling narcotics and domestic violence, including assault. That is facts. It's what you want and why. It's a justified position without argument. The alternative would be something like, mother needs sole legal decision-making because father is an unfit parent. On this date, he did X. On this date, he did Y. He never does blah, 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 et cetera, et cetera, et cetera. That's not what you want in your RMC statement. The judge should be able to, essentially what he or she is going to do is they're going to line up your two RMC statements, and they're going to go, okay, mom wants joint legal decision-making, dad wants joint legal decision-making. Then they're going to look at the parenting time section. Mom wants this, dad says he wants this. They need to be specific so the judge can determine if you agree or if you don't agree, because that is really the entire point of the resolution management conference, is to determine if there are any agreements that can be entered into either on a temporary basis or a permanent basis so that you can enter into what's called a Rule 69 agreement. Rule 69 agreements are partial agreements on any issue within your divorce or custody or modification case. So if the judge is lining up your RMC statements and both people want joint legal decision-making, you will not leave your resolution management conference without standing up, raising your right hand, swearing in, and agreeing on the record to the issues that you agree to, entering into a Rule 69 agreement. Now, those cannot be undone, so they should not be taken lightly. But they're great, okay? Because if we can line up all your issues and you both agree to divide the bank accounts and you both agree that, you know, he takes his car and you take your car, then let's get those issues locked in on the record and thrown away so we can determine what's left and what to do with it. That is the entire point of the resolution management conference.
So I had a question come in online.
Go ahead.
They just kind of wanted to know, what if my wants upset my spouse? Do I still have to give them a copy?
Yes, you do. So the question, just in case you couldn't hear, is what if what I want is going to make the other person upset or angry? Do I have to put them on notice of this? So for instance, let's go back to the mom who's saying that the husband's been convicted of assault. And did I say he was also on drugs? I may have said that. I don't know. you have to include it. And everything that you file with the court has to be given to the opposing party when you file it. So I know that's not the answer you necessarily want. And there are some ways that you can think very carefully about how to couch these issues. If there are issues going on and you really don't want them in the public, we should talk about it, because you have some options on how to keep some aspects of your life private, but still, protect your interests and the interests of your children. So let me know if that doesn't make sense, and I'm happy to answer any follow-up questions. One of the things that we do here, and that I suggest you do, is do some research on your assigned judge. Judges are people. They've got their own inclinations about how they feel about certain things. So you're going to want to know in advance, as much as you possibly can, what some other past decisions have been, so that you know, so that might influence your decisions on how to move forward. So if you've filed a motion for temporary orders, you may have filed that with your petition, or the opposing party may have filed it with their response, or you may have filed it after both the petition and the response have been filed. Hi, how are you? Good. So if you filed a motion for temporary orders, then you may be set for a resolution management conference on temporary orders. Now, this can be super confusing, because it's unclear at that point whether or not this is an RMC where they don't take evidence, or is this a temporary orders hearing where they are taking evidence. It's confusing to us, it's confusing to you. One of the things that we recommend you do is just call the JA and ask, will evidence be taken? And if you look at your minute entry or your order from the court that tells you where to go and when to go, it will say on there usually evidence will not be taken, or evidence may be taken, or evidence will not, or will, or may. So call and find out, because the way you prepare will be different, and we'll talk about that. Okay, the next type of pre-hearing conference is an early resolution conference. Now, this is not like an RMC. These are only scheduled if you have two unrepresented parties, and an early resolution conference is scheduled for 3 hours. So the RMC is 30 minutes, the early resolution conference is 3 hours, and you're set. You go to the family conference provider conciliation services area of the courthouse, and you'll meet with someone who is usually an attorney or trained, and they're there to help you come up with some agreements. You can leave that done. You can walk in, and at the end of 3 hours with this family conference provider, agree on some or all of the issues and leave. It's not like the RMC where they're just looking at statement, agree or not agree. Oh, I'm sorry, I should back up to the RMC for 1 second. So you'll enter into your Rule 69 agreement, and then the court will also determine what needs to happen next for you. If there are 3 issues, let's say, that you don't agree on the parenting time schedule, or you don't agree on property division or whatnot, you will likely be scheduled to do some sort of follow-up alternative dispute resolution where you get sent to a judge pro tem for a mediation or something like that. That is usually what you walk out of the RMC knowing, those things. What have we agreed on? What happens next? Perhaps a status conference will be set months down the road to check in.
Is there a cost for an early resolution conference?
Great question. There is not. There is not a cost for the early resolution conference, and that's unlike a parenting conference. So many times you will be sent to a parenting conference after you're at that RMC. And a parenting conference is similar to the early resolution conference, but not the same. And there's a $300 charge for the parenting conference. That can be waived if one or both people need it to be waived. But great question. So sometimes what I do for clients going into an early resolution conference is they won't schedule one if attorneys are assigned to the case, but you are allowed to attend with an attorney. So twice in the past, I have filed a notice of appearance shortly before the early resolution conference and attended the early resolution conference with the client and the other attorney conference provider and then the unrepresented party. That has been very successful at allowing us to kind of flush through the issues and come up with some really good agreements, because it's a good setting to negotiate. And if you can get a little bit of assistance negotiating from an attorney, then that is an option, and it has worked well for me in the past. Now feel free to jump in with any questions that you have, okay? All right. If you're going to this early resolution conference and you're going to be negotiating these issues, and you've got 3 hours with this attorney who's going to help, bring your evidence, bring your affidavit of financial information, because you can't really calculate child support unless you know your income, his income, the cost of childcare, the cost of healthcare. So bring your evidence. That way, you know, he can say, or she can say, I don't like that. I don't want to pay that much in child support. But if the conference provider is saying, well, do you agree that this is your income? Do you agree that this is her income? Like, it is what it is. You're more likely to get an agreement and take some issues off the table and reduce your costs if you bring that evidence, okay? The other type of pre-hearing conference that you sometimes have is a status conference. Now, most often, if this is a pre-hearing conference for you, it is later on down the road in the case. So you've usually at this point, either you're post-decree, which means you're filing for a modification, or you've done the RMC, you've done the negotiation, there's ongoing issues that need to be discussed. The judge is going to set a status conference, and this literally is a check-in. It's non-evidentiary, meaning the judge is not taking evidence and he or she is not making rulings necessarily. Sometimes happens. But they just want to check in and figure out what's going on so we can figure out how to move forward. They are often telephonic. They're often 15 minutes. So it's really a get to the point, what's going on, inform me, and let's move the case along. They're good things. They help to, you know, get us set up. A return hearing is another name of a pre-hearing conference that is set often. It might be set instead of an RMC. It might be set post-decree, so filing for modification or enforcement. This is usually the first pre-hearing conference, is called a return hearing. And the return hearing can be treated the same way as the RMC, where evidence may be taken and it may not. It's sort of a hybrid between the resolution management conference and the status conference. One key difference is before the RMC, you have to file an RMC statement. Before an ERC, you're not required to file anything. And before a return hearing, you're not required to file anything. We always like to do some sort of a status update or a memo or a pre-hearing statement in advance of a return hearing, because it is in front of the judge and we want the judge to kind of be on the same page. But that's a case-by-case basis. Let's say we're having a return hearing or a status conference on our motion to compel. There's no need to file a pre-hearing statement at that point. Assuming nothing's changed between the time when you filed your motion and the time when you're having your status conference, that would be unnecessary. But feel free to file something to make the judge informed if you'd like to. Open negotiations is a relatively new type of pre-hearing conference that has recently popped up, where attorneys are not involved, not even invited, can't show up, and you are in front of your assigned judge, and the judge is really fleshing out positions, asking for justification. Well, why is it you're asking for sole legal decision making? Tell me what you're thinking. And he or she may take a more active role where they're saying things like, well, you can't really get sole legal decision making just because you've made all the decisions in the past. So that is also another type of pre-hearing conference that you might see. If you need a temporary order, asking for justification. Well, why is it you're asking for sole legal decision? Thanks, Caitlin. Sorry. So let's say you filed a motion for temporary orders. You need a hearing, right? You want a temporary order. Either she's withholding the kids from you. You can't see the kids. You want a temporary order. You're probably going to get sent to an RMC or a return hearing prior to getting your evidentiary hearing. So it can take 30 to 90 days to get in front of a judge. At a temporary orders hearing, it's not like these pre-hearing conferences that we've been talking about. This is an evidentiary hearing, which means you have to gather evidence, you need to be prepared to offer testimony, offer exhibits, file a pre-hearing statement, and there'll be more on that in the sessions as we go forward. Did you have another question? Nope. Okay. So we did deal last week or a couple weeks ago in workshop 3 about how to gather evidence and determine what evidence to bring in. And those are all available. So if you have further questions on that, we can get you that information too. So if you've got a temporary orders hearing, what to expect? You may walk out with an order. They're actually trying out this new system where more and more you are walking out with an order, which is great, because otherwise what happens is the judge takes the matter under advisement, thinks about the testimony, thinks about the exhibits, might look at the exhibits afterwards, and then issue a written ruling, and that can take 60 days. So if you've waited 60 to 90 days to get your temporary orders hearing, and now you're waiting another 60 days to get your ruling, that can mean that you haven't seen your kids in 4 months. That's not good. So anything you can do to speed that up is a good thing. Oh, go ahead. Yes, what's the question?
In regards to like when the father walks out and does not give a location and basically abandons his child, what's the situation with that and proceeding for a divorce or legal separation? And he has not been reachable, and I've made efforts to email and even email his family, and nobody's responding to me.
Okay.
So I don't know where he is. I don't know what he's doing. So in the past, he's done illegal activity, drug selling to make money, and he blamed me for not making money because I wouldn't allow him to do that. So I'm at the point where I'm like, I just want sole legal decision making and not him involved in his life, because I don't know what he's doing right now. He could be back in that, and he's actually on probation for a felony.
Okay.
So what about situations with those types of complex matters involved?
So it's really hard if you can't find the other party. You have a lot of issues here. First, you have to serve the other party in order to move forward. You cannot get divorced or legally separated without serving the other party. So what do you do when you can't find them? Well, you've done a lot of things right. You've contacted his family. You've done everything you can. What you have to do is you have to serve them via publication. And in order to serve them via publication, which means you're posting something in the newspaper.
Okay.
When you really think about that, that's so antiquated. So maybe 50 years ago, people read the newspaper and might see a notice. Now we should be required to take out Facebook ads or something. Anyway, but that's anyway, a little off topic. So what you need to do is you need to demonstrate how you've tried everything and how the only way that you're going to be able to serve this person is through publication. You file a motion asking for the ability to serve via publication. Then you will hopefully get an order that says, yes, you can. At that point, you need to take out an ad, and it'll take a while, but you'll eventually get divorced. And you'll get divorced or legally separated via default, which means you'll get what you ask for. So if you want sole legal decision making and your ex is a drug dealer and a criminal and won't participate in the proceedings.
And he never told me that before I married him. I found out 2.5 months after I was married him that he had 4 warrants.
Oh, geez.
And I didn't know what the warrants were for. I had to call a warrant hotline, and they're like, yeah, he has 4 warrants for his arrest. I'm like, excuse me? So then I asked him, I said, what are these warrants for, and why haven't you told me? I didn't know that I had these warrants. I mean, my brother was claiming that, police were looking for me, but I thought it was just lies. And so I told him, I said, okay, well, what were these for? He's like, I don't really know. So I had to start kind of being like, an investigator and looking up all his cases, and they were like DUIs, marijuana possession, marijuana, selling of marijuana. And then I found out in June just of last year that he had a felony for marijuana, and he was a wanted felon.
Goodness.
And I was not aware of any of this. He didn't tell me any of this.
Yeah.
So my mother actually paid for his bond, $3,600, which was eventually returned, but he was put back on probation. So now it's been a month now that he's been put on, actually not even a month, just a couple of weeks, and now he's just bailed on Friday, just this past Friday. So
well,
can't contact
there's a
him.
lot of challenges when you have somebody who's not showing up. but you may still end up at these pre-hearing conferences. And you're probably going to end up getting divorced via default, which we talked about, I think, in the second session, maybe. I don't know exactly, but
Second or third.
yeah. So one of the things that happens in these pre-hearing conferences, besides figuring out a Rule 69 agreement, is figuring out if there's any court-appointed experts that need to get involved. So the court has the ability to, we talked last time about when you should hire an expert witness, but there is a lot of times when the court will take it upon itself to appoint a third-party advisor to conduct some investigation and make some specific suggestions to the court on specific issues. So a parenting conference we talked about very quickly, it's where each person pays $300. You go see a parenting conference provider. You can bring all of your evidence. You can speak to that person. That person can speak to other witnesses or kids if the court allows it, or if they want to talk to the kids, depending on the age of the kids. And then the parenting conference provider writes a report with recommendations, basically details everything that you've said. So this is not a confidential mediation by any means. But those are used frequently and are pretty effective at figuring out the parties' positions and moving them closer to resolution. Sometimes the court will order a psychological evaluation of one or both parties. At that point, the court will order who pays for it. Another option you may end up with is a limited or a comprehensive family assessment, where the whole family is sent to usually a psychologist or psychiatrist, someone with really specific training and experience to conduct significant investigations on what's going on inside both homes, the mental health of all the parties, maybe grandparents if they're super involved. So that's an expensive and long process. But a court isn't going to want to spend trial time figuring that stuff out. They're going to want to use an expert to figure it out and make some recommendations. Reunification therapy is often ordered when there's a complete breakdown in the relationship between the children or the child and one of the parents. Or reunification therapies have the ability to kind of make evolving orders to hopefully reunify the parent and the child and rebuild that relationship. A court-appointed advisor is similar to a parenting conference provider, except just broader in scope. So it's somewhere between the comprehensive family assessment and the parenting conference, but essentially they do the same thing: investigate issues, make recommendations.
Okay, and what if I have a DCS case already? Because it was actually in the hospital after I delivered my son. 2 days later, there's a DCS investigation on him for how he treated my son. Literally.
In the hospital?
In the hospital. He threw objects in the hospital room. He yelled at the baby.
Okay.
So actually a DCS worker came in and filed a report and said that he's not allowed to be left alone with the child.
Okay. All right. So great question. What happens if DCS is involved and there are certain, if DCS is involved, then they may have taken custody of your child. If DCS has taken custody of your child, at that point, your action is not a family court action. Your action is in juvenile court, which is a completely different set of rules. You are appointed an attorney in juvenile court. It's a weird place where you're somehow in between a criminal action and a family court action. And their goal is to get parents services to hopefully relinquish custody. Now, if DCS investigates and they find that something's unsubstantiated or they don't take custody, then
It was just neglect on his part.
he was being investigated for neglect.
Yeah, it was actually, they wrote up the report. It was neglect that they put for him towards my son, because he literally walked out the hospital and didn't tell me where he went and just left my son crying. And
How old is your son now? 2 months. Okay. Well, the good news for you is that it sounds like it's a great thing that he's gone. But if there are orders from DCS and orders from family court, it can get very confusing, and it's something that's difficult to navigate. If there is an order, like in your case where DCS has said no contact with father, at that point you may be married, you may not be married. But if there's an order that says no contact with the father, you cannot allow that other parent to see your child, or you are facing the risk of DCS coming in and saying that you have failed to protect your child and losing custody to the state. So I cannot stress this enough. If DCS is involved, the stakes are high. They have a lot of power, and you don't want to make them angry. You just don't.
I never left because the orders were to not ever leave the, the child alone with the father.
Mhm.
And so I made sure that,
Great.
my mom was always in the house.
Yep.
And I was always around him. But he still managed to verbally degrade my son in front of me.
Mhm.
And so I would just go in and tell him, you just need to go. Like if you're gonna talk, you're not gonna talk to my son that way.
Mhm.
And if you think it's okay, then you need to go. And
When you have a situation like yours, we're even teetering on, whether or not to terminate parental rights, and that's not. Let's get through the material, and then we'll be in the open Q&A, and then we can talk about termination. But let's get through this. We're almost done. We already talked a little bit about parenting conferences and how they work and how they're $300. We talked a little bit about comprehensive family assessments. They are for very complicated situations. Both people are slinging mud at one another, and there's a thorough investigation of each family, extended family, stepchildren issues. Like it can be intense. A limited family assessment is more specific. So let's say you have a child with a mental health problem, a teenager who's really struggling with behavioral or mental health issues. It may be, and the parents really disagree, and the child's having problems at both houses. What's a judge going to do with that? You've got a really complicated situation. It might be best at that, but both parents are fit parents, right? Okay, so there's no, neither parent is abusive. We just have a really tough issue. That's a great time for a limited family assessment where an expert comes in and really looks at the child, both parents, and comes up with a specific recommendation on a specific issue. We talked a little bit about therapeutic intervention or reunification. At this point, you've usually got some parental alienation going on most of the time. It's odd when that's not the case, although it can happen where you've just got, let's say, a parent, moved away or was deployed for a long period of time. And it's not that one parent ever necessarily interfered, but for whatever reason that there's been such a breakdown in the relationship that you would need some sort of therapeutic intervention or reunification. Now, my advice, especially on this, is if you can work with the other parent to do this privately, in my experience, it's faster, cheaper, and more effective. But when there's an element of parental alienation going on, then one parent doesn't want the child to see the other parent, and you're almost stuck begging the court to order that the child and the parents be sent to therapeutic intervention or reunification therapy. And you need these sorts of third-party extras when there are issues going on. They're not for every case. It's not for minor disagreements. It's for either a long history of conflict that just can't get resolved. So maybe there's not really like a good reason to have conflict. Like there's no substance abuse, there's no domestic violence, there's no mental health considerations. There's just such high conflict that you need a third party involved. Or if you have any of those other issues, somebody's been gone for a long time, or any of these other issues, addiction, violence. And that is it for today for pre-hearing conferences. And now we can open it up to any questions that anyone has.
Well, my question, about just keeping my son safe.
Mm-hmm. So in your case, what we can't do today, and it's I know I've given you the disclaimer, we've written it all over the place, but what I can't do is I can't give you legal advice today. We can just give information. So in the case where one parent is really, you believe that the other parent is really dangerous and really shouldn't be around your child, you want to seek a court order that they not have any parenting time and that you have sole legal decision making. Getting that type of order is very difficult. But if you have an absent parent who's a convict and has a history of domestic violence against a child beginning in the hospital, those are the types of facts where you could see a judge saying, yes, I'm going to enter an order of no parenting time and sole legal decision making to one parent. So it's a high bar, but it can be met. And there are circumstances, there are cases that I've worked on where one parent has ended up with no parenting time, or Skype parenting time only.
Wouldn't though things like having CPS already having an opinion against that only help add to the person?
Yes, I mean, if DCS has said no contact, and it sounds like in your case, DCS said no unsupervised contact. So if dad in that case were to show up in family court, if he weren't absent, if you didn't get a default decree and he said, I want parenting time, it would be unlikely that he would get no parenting time, and it would be more likely that he would have supervised parenting time, because there's in general a strong desire to promote healthy relationships between children and both parents. And there's a strong desire to rehabilitate any parents who don't currently have parenting time or don't have the skills to be a good parent. The desire of our court system is to get that person those skills as opposed to cutting the parent out of the child's life. But in your case, with your facts and someone who doesn't show up, I would be, it wouldn't surprise me if a judge did agree that that person should have no parenting time. And then that brings us to the next logical step is, well, when can a parent's rights be terminated? When do because even if you get an order of no parenting time, someone can always come back and ask for a modification. You can't do it all day, every day. You have to wait 6 months or a year, depending on your circumstances, to ask for a modification of parenting time. But in general, you can ask. And and you have a 2-month-old. So, I mean, that's a lot of years of potential modifications. So there's a statute that allows one parent to petition the court to terminate another parent's rights. That's actually in juvenile court. It's not in family court. And the statute has various grounds under which you can ask to have those rights terminated. If a parent's rights are terminated, they are no longer the legal father or legal mother of that child. They can't come back and ask for modification. They can't come back and ask for contact. That doesn't mean that if he didn't turn his life around and, come to you 10 years from now that you couldn't allow contact, but he wouldn't have standing to go back and ask the court to modify parenting time and get parenting time.
So the termination of rights is on his part?
Right. You could file to terminate his parental rights. One of the grounds, the most common grounds, is abandonment. And abandonment, I don't have this memorized. It's either 6 months or a year that you have to show no contact and no attempted contact. And that's just one of the grounds. Now, juvenile court doesn't like to terminate parental rights. So there have been cases where we have asked to terminate a parent's rights, and maybe the other side has even agreed, and the court has said no. Because it's a big responsibility.
Can't go back.
You can't go back. If you have a child, you have a lot of responsibility to this child. A court doesn't want to really leave a child with only one legal parent. It cannot be undone. So let's say you hate this other person. You've got a young couple who they don't like each other anymore. They're really fighting, and the dad's like, fine, I want to give up my rights. And that's how it usually happens under these circumstances. A judge may say, no, you guys need to work through it, make it happen. It is more likely that in our experience, you're able to terminate when there is a step parent who's willing to adopt. So I have some other questions here that have come in over the week, but are there any others that are?
Well, I have just one here.
Okay.
How can I get my husband out of the house? We both want to keep it. He won't move out. Will the judge make him move out? I don't want my kids to feel like I've been abandoned because one of my friends moved out and now there's just a lot of aggression from her kids. They think she's awful and now the divorce has been final, but there's still,
Okay.
like, so the person just doesn't know exactly what to do.
This is a tough situation. So you're breaking up. Nobody's necessarily been violent, but you're breaking up. Things are kind of tense. You don't want to live together. You don't want to leave. You want him to leave in this case. Will a judge make him leave? I think we have, this keeps coming up. This must be a really common issue because people have been asking about this a lot. And I don't have a great answer for you. You can file in your motion for temporary orders and ask for to be granted exclusive use of the house. And a judge may or may not order that one of you have exclusive use of the house. And the problem here is you own the house, he owns the house. Your kids are in the house, his kids are in the house. You want to live there because things are volatile, he wants to live there because things are volatile. How does the judge choose who he or she should make move out? And once that happens, once you go from having one house to having two houses, things get more expensive, things get more complicated. Now we need a parenting plan. If you're living together with your kids while you're divorcing, things are just kind of easier, right? It's status quo. It's kind of an extension of your marriage. And eventually a judge will decide. Someone is going to either get the house or the house will be ordered sold. And there's a couple things you can think about here. If you want to stay in the house, you need to take a look at the overall property that you all have and figure out, can I stay in the house and buy out his interest? Am I going to be able to refinance this loan? Because the judge is not going to really make your husband stay on your loan with you. That's eating up available credit for him. It might be preventing him from getting a new house. So do you have the ability to refinance that property, buy out your husband's interest, and pay the mortgage and all of the expenses for the house? Take a long, hard look at that before you decide. And then the second part of her question was, I'm afraid if I move out, my kids will feel that I've abandoned me. And she said that that happened to a friend of hers.
Right, that's what kind of prompted the thought, was that her friend's kids thought that immediately, but even now, after the dust is settled, the kids still aren't particularly treating her friend well. So
there are so many emotions that come along with the family home, not just for the parents, but for the kids. And so this is seriously worth considering. And you should think about your children, the ages of your children. Where are you moving? Are you moving into a place that accommodates them? Can they come with you? Or are you leaving to go to your sister's couch and now you're not going to be able to have parenting time with your kids and you've left them behind? That isn't a good situation. In my opinion, depending on the facts, and this is a decision that you have to make, but that's not good. If you're moving out, you really should consider working with your spouse on that to make sure both people are committed to your children's well-being, which means knowing that neither of their parents have abandoned them. Managing their emotions and where they're at developmentally is very, very important. So I think it's wise for her to really consider that. Talk to her husband, see if they can't come to an agreement and really think long-term. Long-term, what are we doing with this house? Are we keeping it? Are we selling it? Are we refinancing it? What do we want to do? But it's a great question. Any other questions? No? One that came in this week was a really good one. My wife homeschools. Our kids have been homeschooled for the last 4 years. She wants to continue homeschooling. I'm not entirely opposed to having her homeschooling, but does that mean I have to pay for her to stay at home and for all of her expenses until the kids are done with school? Sort of. I mean, if you are saying, yes, I want my wife to homeschool, then practically speaking, she's a teacher, right? That's her job. She might be able to work part-time, but she can't really probably get a full-time job and homeschool. I guess sometimes people might do that. There's online school. So it's kind of a practical question more than a legal question as far as homeschooling goes. If you want your wife to homeschool, then this is really something where we really need to think about what this means. How does this look? Is there enough money to go around? What are our options? If there is not enough money to go around, and this situation has come up a lot of times, and most of the time that's the case, there isn't enough money to go around to spend for one person's income to support two households comfortably.
Mhm.
It's just tough. Most people find it tough to support one household comfortably, let alone two. So most of the time, this means the children are no longer homeschooled and they're going to school, and the wife is entering the workforce. And the second half of this question was that my wife was an attorney. Will the judge say that she can or should earn what an average attorney makes when calculating spousal maintenance and child support? If your wife has been home with the kids homeschooling for the last 5 years and she's a non-practicing attorney, then her earning capacity isn't the same as a current practicing attorney. So a judge is not most likely to simply look at what an attorney can make and attribute it to her. She's been out of the workforce, presumably supporting your children and your career, and that sort of has to be equalized. While we give her a chance to start practicing again, if that's what she wants to do. So she will be imputed some sort of an income. What that is will be specific to her facts, what she wants to do. And at that point, one of the things to consider would be getting a vocational assessment. A vocational assessment is where an expert who determines people's earning capacity, they really know the labor market, and they meet with this person and they determine, okay, what are your skills? When you were an attorney, where did you work? Are you licensed in this state? Are you not licensed in this state? What type of law did you practice? What other jobs have you had? What other skills do you have? Let's say you've been running a business on the side while you've been homeschooling your kids. I mean, you've got some skills here that need to be considered when determining what your options are. What do you want to do in the future? So all of that will be considered, and then the expert will create a report that says this person's earning capacity is between X and Y. That is typically the number that will be used to determine child support and considered when determining spousal maintenance.
We're not a lot of questions.
No other
today.
questions? I only have one more that came in through the week, and it's a good one. It's from a gentleman who says, my wife is a hairdresser and she makes up to $250 a day. Her taxes show that she made $6,431 in 2017. What do I do? How can I show what she really makes and what she's capable of earning? The money comes in cash. This is an issue for hairdressers, for servers, for lots of small business owners who maybe run, what's it called, solopreneurs, like this whole new economy of freelancers and solopreneurs who run their own businesses, and they are their own business. It's not like you can really value that as a business because we're talking, one person working for themselves. So, and they may not have books that look like, my business or a grocery store. At that point, typically the easiest way to determine what's there is to look at what's being spent. At that point, your bank accounts will show how much money is going out for things like groceries and your credit card statement. So you can't do anything about the money that's coming in and out in cash. But if you can show that, $5,000 a month is being spent and you're responsible for $2,000 of it, then you have an easier time of arguing to the judge that she makes at least $3,000 a month or that sort of thing. So you're doing kind of a backwards analysis to come up with your position on what her income should be. Okay. So next week, what do we go into? Go back. I guess it's not next week. It's the first Tuesday of February.
The 6th.
The 6th, February 6th. And we'll talk about divorce negotiations. This is going to be a great topic because most divorces and family law matters do end with settlement. And there are a ton of practical, really useful tips on how to best set yourself up for a negotiated outcome, which in my opinion is always the goal. Always, always, always the goal that you as parents are making decisions for yourselves and for your children and not handing it over to someone else. So, so we will see you on February 6th.